He was 19 years old. He could barely read. He had never been in serious trouble in his life. And on a single evening in the autumn of 1983, he walked into a police station voluntarily because he thought he had done nothing wrong and had nothing to fear. 4.5 hours later, he walked out having confessed to the rape and murder of an 11-year-old girl. He had not touched her. He had never met her. He did not even know her name. But the police had a confession, a written statement, full of graphic details, with his signature on the bottom. And that piece of paper would cost Henry Lee McCollum the next 31 years of his life, 20 of them on death row, waiting to be executed for something he never did. This is the story of Henry McCollum and his younger brother Leon Brown. And if you are new to this channel, every single week we cover real people who were destroyed by a system that was supposed to protect them. Subscribe and turn on notifications right now because the cases coming up on this channel are going to leave you shaking. Now let us go back to a small town in North Carolina in 1983. The town was called Red Springs. It sat in Robeson County, a rural corner of North Carolina that was, and remains, one of the poorest counties in the state. It was a tight community. Everybody knew everybody. And in the late summer of 1983, it was shaken by a discovery that horrified the entire area. The body of an 11-year-old girl named Sabrina Bowie was found in a soybean field near a convenience store. She had been sexually assaulted and suffocated. She was a child. The community was devastated. The police were under enormous pressure to find whoever had done this and deliver justice to Sabrina and to her family. Henry McCollum was not from Red Springs. He had grown up in Jersey City, New Jersey, and had come down to North Carolina for a few weeks to spend time with his mother, Mamie, and his younger half-brother, Leon Brown. Henry was 19. Leon was 15. Both boys had intellectual disabilities. Henry had an IQ of 51. Leon's IQ was 49. To put that in context, an average IQ is around 100. An IQ of 51 means a person functions with the mental and comprehension abilities of a young child. Henry could not properly read. He could not fully understand legal documents. He could not process complex spoken instructions or follow fast-moving conversations the way most adults can. He was, in the technical language of psychology, profoundly intellectually disabled, and none of that protected him from what came next. The investigation into Sabrina's murder began quickly. Officers from the Red Springs Police Department started interviewing local residents and looking for leads. She had no evidence. She had no direct knowledge of anything. She had heard a rumor about a teenager who seemed odd to other kids because of his disability. That was it. In the course of that investigation, a high school student came to police and told them that she had heard a rumor at school that Henry McCollum, the teenager from out of town who people said acted strangely, might have been involved. That was the entire basis on which police went to Mamie Brown's house and brought Henry in for questioning. They told him to come down to the station. He went. He had nothing to hide. He thought it would be a quick conversation and he would go home. What happened in that interrogation room over the next 4.5 hours is the foundation of one of the most catastrophic failures of justice in the history of North Carolina's criminal courts. Henry was placed in a room with police officers. No lawyer was present. His mother was not permitted to be with him. The officers told him they had a witness who said he was involved in Sabrina's murder. That witness did not exist. It was a lie designed to pressure him into talking. They told him he was going to face the death penalty. They yelled at him. They kept him in that room for hours without adequate rest or food, pushing and pushing until a 19-year-old boy with the cognitive capacity of a young child simply broke down. After 4.5 hours, Henry began talking. He did not confess from memory or from guilt. He confessed from desperation, from exhaustion, and from the only logic available to a severely disabled teenager in an interrogation room at night, that if he told these adults what they wanted to hear, they would let him go home. He had been told that if he just explained what happened and cooperated, he would be allowed to leave. And so Henry began to speak, and as he spoke, the officers fed him details about the crime, details he could never have known on his own because he had not been there. And Henry incorporated those details into the story he was telling. The officers wrote up the confession. Henry, who could barely read the document placed in front of him, signed it. As Henry constructed this false account, searching for ways to make it believable and to spread responsibility away from himself, he added other names to the story. He said his brother Leon had been involved, along with 2 other boys from the area. By a terrible coincidence, Leon Brown and his mother had come to the police station that same evening to wait for Henry. They were in the building when the officers learned from Henry's statement that Leon was supposedly involved. Police pulled Leon out of the waiting area into a separate interrogation room and began interrogating him. Leon Brown was 15 years old. His IQ was 49. He could not read at all. He could not understand what was happening to him. Within 30 minutes of being interrogated, 30 minutes, Leon had also signed a confession. He had not been able to read a single word of it. He signed it anyway. The two confessions were full of problems that should have been obvious to any honest investigator. They contradicted each other on basic details. They described the other two boys Henry had named as being present, but police quickly determined that those two boys had watertight alibis and could not possibly have been there. The timeline in the confessions did not match the known facts of the case. There was no physical evidence linking either Henry or Leon to the crime scene. No fingerprints, no DNA, no fibers, no witnesses who had seen them anywhere near where Sabrina was found. Nothing. The only evidence the prosecution had were two signed statements produced in a single evening from two severely intellectually disabled boys who had recanted both confessions the very next day and said they had been fed the details and pressured into signing. Those two pieces of paper, which should never have been used in court, became the entire case. But here is the detail that transforms this from a terrible story into something almost beyond comprehension. The real killer was not hiding. He was not a mystery. He was not some unknown figure that investigators had no way to find. His name was Roscoe Artis. He was 43 years old. He had a criminal history of sexual assaults stretching back to 1957, 26 years of documented violent behavior against women. He had been wanted on suspicion of another rape and murder in Gaston County just a few years before Sabrina was killed. And when Henry and Leon were sitting in that police station on the night of their interrogations, Roscoe Artis was living in a house less than 100 yards from the soybean field where Sabrina Bouie's body had been found. He was their next-door neighbor. He was right there. Within weeks of the interrogation of Henry and Leon, Artis raped and murdered another young woman, an 18-year-old named Joanne Brockman, just 1 mile from where Sabrina was killed. He used the same methods. She was raped, strangled, and left in a field. He was caught almost immediately, confessed, and was arrested. The same prosecutor who would soon put Henry McCollum on trial for Sabrina's murder had already convicted Roscoe Artis for Joanne Brockman's murder before Henry's trial even began. The prosecutor knew Artis lived next to the crime scene. The prosecutor knew Artis was wanted for another almost identical rape and murder. The prosecutor knew the fingerprints found at Sabrina's crime scene had never been matched to Henry or Leon. 3 days before Henry's trial started, law enforcement actually requested a fingerprint comparison between Artis and the prints found at the scene, and then that request was cancelled after the trial concluded. Nobody ever told Henry's defense attorneys that Roscoe Artis existed. In 1984, Henry McCollum was convicted of the rape and murder of Sabrina Bouie. He was sentenced to death. Leon Brown was also sentenced to death, making him at 16 years old the youngest person on North Carolina's death row. The prosecutor who tried them was a man named Joe Freeman Britt, listed in the Guinness Book of World Records as the deadliest prosecutor in America, with 47 death penalty convictions to his name. He had just weeks earlier convicted the real killer of another murder, committed in the same town, in the same fashion. He sent 2 boys to death row anyway. Henry McCollum arrived on death row at Central Prison in Raleigh, North Carolina in 1984. He was 19 years old when he was sentenced. He would be 50 years old when he was finally freed. Between those 2 moments, 30 years of living inside a system that had decided he was a monster and intended to kill him for it. Henry McCollum endured a form of suffering that is almost impossible to put into ordinary words. Death row in North Carolina is not a communal experience. It is solitary. Each man lives alone in a small cell for most of every day, with limited contact visits, restricted movement, and the constant psychological weight of knowing that at some point the state intends to execute you. For most people on death row, that weight is the heaviest thing they will ever carry. For Henry, it was compounded by something that made his situation uniquely devastating. He was intellectually disabled in a world that required constant comprehension of complex legal documents, court filings, appeal procedures, and bureaucratic processes. He could not fully understand what was happening to him at any given stage of the process. He could not read the papers that were filed in his name. He depended entirely on lawyers, and, when lawyers were absent, on the kindness of other inmates to help him navigate a system that was simultaneously trying to kill him. The years passed, and with each passing year, the machinery of death moved closer. Henry watched men he had known on the row be taken away to be executed. When executions happened, he became so distressed, so completely overwhelmed by the knowledge that the state was killing people for crimes they may or may not have committed, and that he himself was next in that line, that he had to be removed from the general death row population and placed in isolation to prevent him from harming himself. He was suicidal. He was severely depressed. He was a man with the cognitive capacity of a young child, trying to survive inside one of the most psychologically brutalizing environments a human being can be placed in, with no end in sight and no mechanism available to him to make anyone hear his truth. His brother Leon had been somewhat more fortunate in one specific sense. On retrial in the early 1990s, Leon's death sentence was reduced to life imprisonment. He was still in prison for a crime he had not committed, but at least the date of his execution was no longer circled on a calendar somewhere. Henry was not so lucky. On retrial, he was convicted again. The confession, that same coerced, contradicted, factually impossible written statement from 1983, was played to the new jury, and the new jury convicted him again. He returned to death row. He became the longest-serving inmate on North Carolina's death row. Year after year, appeal after appeal, the courts rejected his claims. The confession had been found voluntary by the trial judge. 2 different juries had heard it and convicted him. 2 different appellate courts had reviewed the case and upheld the conviction. At every level, the system looked at Henry McCollum and said, "You did this, and you are going to die for it." What nobody outside the case fully appreciated, what the legal record at that point simply did not reflect, was just how much the police had known and withheld. The police file on Henry's case had been declared lost. His lawyers could not review it. They did not know the file contained evidence about Roscoe Artis. They did not know that Artis had been investigated as a possible suspect and quietly dropped. They did not know that the fingerprint request had been cancelled. They were operating in the dark, defending a man with a signed confession against a system that had made up its mind and hidden the documents that might have changed everything. And then something happened that the people who wanted to keep Henry on death row had not anticipated. Justice Antonin Scalia of the United States Supreme Court decided to use Henry McCollum as an argument. In 1994, when Justice Harry Blackmun wrote publicly that he could no longer support the death penalty in good conscience, Justice Scalia wrote a response. And in that response, he described the crime for which Henry had been convicted in graphic detail, presenting it as precisely the kind of case that made the death penalty not just acceptable but necessary. Scalia wrote, describing what he characterized as Henry's crime, that lethal injection by comparison seemed merciful. He used an innocent man as the poster child for capital punishment. He used a man who had been framed, whose confession had been fabricated, whose actual innocence was being actively buried by a police department that had lost its own file. And he used that man to tell America that execution was justified. Outside the courtroom and the death chamber, the political machinery was also working. In 2010, during North Carolina state legislative elections, the North Carolina Republican Party produced campaign flyers with Henry McCollum's mugshot on the front. The flyers were used to attack Democratic candidates who supported the Racial Justice Act, a law designed to allow defendants to use statistical evidence of racial bias in death penalty cases. Henry's face, his name, and his convicted status were used to tell North Carolina voters that this was what happened when he was soft on crime. This was what needed to be executed. A man who had been illiterate when he signed his confession, who had recanted it the following day, who had maintained his innocence for 27 years, was being used as a bogeyman in political advertising. And the people printing and mailing those flyers had no idea, or perhaps did not care, that the man whose face they were using was innocent. Henry had a lawyer named Kenneth Rose, who had been representing him for years at the Center for Death Penalty Litigation. Rose knew the confession was wrong. He knew the case was broken, but without the missing police file, without access to whatever evidence the Red Springs Police Department had collected and apparently never disclosed, there was a ceiling on what he could do. He needed something to break the case open from the outside, some new angle, some fresh piece of evidence that could not be explained away by the existing record. That break came from the most unexpected direction. Leon Brown, sitting in prison serving his life sentence, was approached by a fellow inmate who told him to write to the North Carolina Innocence Inquiry Commission, a state body created to investigate potential wrongful convictions. Leon could not fill out the form himself. His disabilities made it impossible. Another inmate helped him complete it. Leon submitted it, and the commission agreed to look. What the commission found when it began pulling the threads of this case apart is something that every person who believes in the justice system needs to hear. The police had never compared the fingerprints found at Sabrina Bouie's crime scene to Roscoe Artis. The prosecutor who had convicted Artis for Joanne Brockman's murder had never disclosed to Henry and Leon's defense lawyers that Artis existed, that he lived next to the field, or that he had been connected to crimes committed in an almost identical manner in the same small town. The physical evidence from the crime scene, clothing, beer cans, cigarette butts, had been sitting in storage for nearly 30 years, and when the commission tested that evidence against modern DNA databases, the result came back with the kind of clarity that 3 decades of courtroom argument had never managed to produce. A cigarette butt found near Sabrina Bouie's body contained DNA. That DNA matched one person, not Henry McCollum, not Leon Brown. The DNA matched Roscoe Artis, the convicted rapist and murderer who had lived 100 yards from the crime scene, who had killed another young woman in the same town using the same methods just weeks later, who had been convicted of that crime by the same prosecutor who then put Henry and Leon on death row, and who had been quietly sitting in a North Carolina prison for 30 years while 2 innocent men rotted in cells for what he had done. On September 2, 2014, Henry McCollum and Leon Brown walked out of Robeson County Superior Court as free men. Henry was 50 years old. Leon was 46. Between them, they had spent 62 years in prison for a crime committed by a man who had been right there, in plain sight, in a file that had been declared lost all along. The moment in that courtroom when Judge Douglas Sasser vacated their convictions was described by people who were present as one of the most emotionally overwhelming scenes they had ever witnessed in a legal setting. Leon smiled broadly when the judge spoke the words that meant he was free. Henry dropped his head and closed his eyes. His lawyer, Kenneth Rose, who had fought for him for 20 years, later described Henry's face in that moment, the way the decades of suffering were visible in his expression, the way freedom and grief arrived at exactly the same time, inseparable from each other. In the back of the courtroom, Sabrina Bouie's family held each other and wept. Their daughter had been dead for 31 years. The 2 men they had believed were responsible for her death were walking out of court as innocent men, and the man who actually killed her had never been charged with it. That last detail is one of the most infuriating in the entire case. Roscoe Artis died on December 15, 2020, at the age of 82, while serving his life sentence for the murder of Joanne Brockman. He was never formally charged with the rape and murder of Sabrina Bouie. The DNA placed him at the scene. A fellow death row inmate had confirmed that Artis had told him McCollum and Brown were not responsible. Artis himself had made statements to investigators suggesting he knew more than he admitted, but the statute of limitations on the crime, combined with legal complexities around prosecuting a man already serving life for another murder, meant that Sabrina Bouie's actual killer died in a North Carolina prison, having never answered in court for what he did to her. The prosecutor who had sent Henry and Leon to death row was Joe Freeman Britt, the man the Guinness Book of World Records had celebrated as America's deadliest prosecutor. Britt had personally convicted Roscoe Artis for the murder of Joanne Brockman just months before he put McCollum and Brown on trial. He knew Artis lived next to the crime scene. He knew about Artis's long history of sexual violence. He knew the fingerprints at the scene did not match either defendant. When Henry and Leon were exonerated in 2014, Britt was retired. He told a reporter that he still had no doubts about their guilt. He said that finding a cigarette butt with Artis's DNA on it was not evidence of anything meaningful. He said this about a case in which the only evidence against his 2 defendants had been confessions written by police and signed by intellectually disabled teenagers who could not read them. When Henry was released, he was given $750,000 by the state of North Carolina as the maximum compensation available under state law for wrongful conviction. That figure, $750,000 for 31 years on death row, works out to roughly $24,000 per year for each year that Henry McCollum spent in a 6-foot by 10-foot cell, watching men be taken to be executed, becoming suicidal during those executions, being targeted by other inmates because of the nature of the crime he had supposedly committed, losing his 20s and his 30s and his 40s to a system that had built its case on a lie he received. $24,000. Leon received the same amount. The money disappeared quickly. Henry, who was intellectually disabled and had spent his entire adult life in prison, had no experience managing finances, no understanding of interest rates, no frame of reference for the value of money in the outside world, and no protection from people who saw an intellectually disabled ex-annery with a compensation payout as an opportunity. Within 7 months of receiving $750,000, Henry was broke. He had been targeted by predatory lenders who charged him 38% interest. Documents later obtained by journalists showed he owed $130,000 on $65,000 worth of loans. He told a reporter at one point, "Sometimes I feel like I shouldn't be out here." Leon, whose disabilities were even more profound than Henry's, was placed in a group home. He could not manage independently. He told reporters from his group home that he did not belong there and that he wanted his freedom. A judge had placed him there, and a judge's decision kept him there. In 2016, the brothers filed a civil rights lawsuit against the officers who had coerced their confessions, the agencies they worked for, and the city of Red Springs. The case laid out in legal detail exactly what had been done to them: the fabricated evidence, the suppressed exculpatory material, the fingerprint comparison that had been requested 3 days before Henry's trial and then quietly cancelled after it concluded. In May 2021, a federal jury delivered its verdict. It awarded Henry McCollum and Leon Brown a combined total of $75 million, $31 million each, $1 million for every year they had been wrongly imprisoned, plus $13 million in punitive damages assessed against the individual officers responsible for the misconduct. It was the largest wrongful conviction award in the history of the United States. A judge later reduced the amount by $36 million on appeal, but the message the original jury sent was unmistakable. The citizens of North Carolina, having finally heard all the evidence that had been hidden from 2 previous juries, looked at what the state had done to 2 disabled teenagers and delivered the strongest financial verdict they were empowered to give. Here is something that does not get discussed enough when people tell this story. Henry McCollum's face was used twice at the highest levels of American public life as an argument for maintaining the systems that had destroyed him. The first time was in 1994, when Supreme Court Justice Antonin Scalia used the crime Henry had supposedly committed to justify lethal injection as a method of execution. The second time was in 2010, when a major political party used Henry's mugshot in campaign advertising to defeat a law designed to protect innocent people from racial bias in death penalty cases. Both of those uses happened while Henry was sitting on death row, still there, still innocent, still waiting, still being failed by every level of the system simultaneously. A man was used as a justification for the death penalty by one of the most powerful judges in the world. And that same man had been framed by police who had hidden the evidence that would have freed him. In 2015, a year after Henry's exoneration, Supreme Court Justice Stephen Breyer cited his case in a landmark dissent, arguing that the death penalty was unconstitutional. He pointed to Henry as evidence that the system could not be trusted to get it right, that executing people created an unacceptable risk of killing innocent people, because the mechanisms that were supposed to prevent wrongful convictions had demonstrably failed in exactly this case. Scalia had used Henry to argue for the death penalty. Breyer used the same man to argue against it. Between those 2 citations was 31 years of suffering by a person who had nothing to do with any of it. The girl that Henry and Leon were convicted of killing was Sabrina Bowie. She was 11 years old. She had gone out one evening to return her neighbor's bicycle and never came home. Her family spent 31 years believing that justice had been served, that the men who killed their daughter were locked away. When the exoneration came, they had to absorb 2 truths at the same time: that the men they had believed were responsible were innocent, and that the man who was actually responsible had been living right next door and had never been made to answer for what he did to Sabrina. Her family had been victims of this case twice. First, when Sabrina was killed, and then for 31 years while the wrong men served time and the real killer breathed free air under their noses. Roscoe Artis was never charged with Sabrina's murder. He died in prison in December 2020, serving time for Joanne Brockman, not for Sabrina Bowie. He had a criminal history of sexual violence stretching back to 1957. He had been wanted for another rape and murder when he moved to Red Springs. He had lived 100 yards from where Sabrina's body was found. His DNA was on a cigarette at the scene, and the police had never, not once in 31 years, not during the original investigation, not during the retrials, not during any of the appeals, been honest with the defense about how much they knew or how close they had come to looking at the right person. Henry McCollum today lives in Virginia with his fiancée. He has spoken publicly about his experience. He has said, in the understated way that characterizes everything he says, that there are still a lot of innocent people in prison who do not deserve to be there. He did not come out of death row bitter and broken in the way the system had perhaps assumed he would. He came out determined. He spent several years working on a book about his life. He donated advocacy time to criminal justice reform. He has been, in the years since his exoneration, exactly the kind of person the system never imagined he would be. Someone who refused to be defined by what was done to him. Leon Brown lives in a group home in North Carolina. His disabilities are severe enough that independent living is not possible for him. He sees his sister regularly. He has said that he wants his freedom. A judge decides what freedom means for Leon now. The same way a judge decided what freedom meant for him in 1984. He is free from death row and from prison. He is not free in the way that a person who was never wrongly imprisoned for 31 years would be free. The North Carolina legal system issued them pardons of innocence in 2015. The governor signed those pardons. Henry and Leon are, in the eyes of the state, formally and officially innocent. The police officers whose misconduct sent them to death row have never been criminally charged. Joe Freeman Britt, the deadliest prosecutor in America, retired and went home. The fingerprint comparison that was requested 3 days before Henry's trial and then cancelled after it, concluded was never explained. The police file that was declared lost for years and then found to contain evidence of Artis's connection to the crime was never the subject of a full public accounting. The system found 2 innocent men, paid them a portion of what it owed them, and moved on. There is one more thing that needs to be said about this case and about what it means. Henry McCollum's exoneration was a near miss. The cigarette butt that contained Roscoe Artis's DNA was the only item from the crime scene that survived 31 years of storage in a condition usable for modern DNA testing. Everything else had degraded. If that cigarette butt had been lost, if it had been stored incorrectly, if the state had disposed of the evidence before the Innocence Inquiry Commission got to it, Henry McCollum would still be on death row right now, or he would have been executed years ago. And this would be a story like Cameron Todd Willingham's, a story about a man who was put to death before the truth could catch up with him. Henry's lawyer, Kenneth Rose, said it best after the exoneration. He said, "Henry and Leon were freed because of a single cigarette butt. Now, think about all the other cases where there is no biological evidence left. Think about all the men and women on death rows across this country who were convicted the same way Henry was, by police who wanted a conviction, by prosecutors who wanted a record, by juries who were never told the full story, and who have no cigarette butt waiting for them, who have no Innocence Inquiry Commission looking at their files, who have no one filling out a form on their behalf because they cannot fill it out themselves. How many of them are still in there? That is the question this case leaves behind. That is the question that Henry McCollum's face, the face that Justice Scalia used to justify execution and that political parties put on campaign flyers to win elections, actually asks, if you are willing to listen to it. If this story affected you the way it should, subscribe right now so you never miss a case on this channel. Share this video with one person who has never heard this story, because the only way these names stay alive is if we keep saying them. Leave a comment telling me what moment in this story hit you the hardest.